City Council. Watch the meetings on RPV TV, YouTube, and the city's website at rpvca.gov. Let's stay connected, and remember, we are RPV together. Hello, I'm Ara Maranya, Rancho Palos Verdes City Manager. If you've ever wondered about what city employees do to keep our community running smoothly, then that may be a sign for you to apply to the city's Leadership Academy, a program designed to inform and educate citizens about the operations of local government. The Fall 2025 program will focus on our main departments: administration, community development, recreation and parks, public safety, finance, and public works. Presentations will be conducted by the department directors with other speakers including myself, Mayor David Bradley, Mayor Pro Tem Paul Seo, and more. Our Deputy City Manager, Catherine June, has more information to share about the program.
Hello, I'm Catherine Jun, Deputy City Manager of Rancho Palos Verdes. Leadership Academy is not only a great way to learn about city functions, but it is also a stepping stone into the world of local government. Many previous participants have continued their involvement by serving on our advisory committees. If you have any interest in running for local office or working in the public sector, then you are encouraged to apply. Please note that space is limited and approved on a first-come, first-served basis.
I'm very excited and enthusiastic about this year's program because not only is this a great opportunity for you, the citizens, but it's also a great opportunity for us, the city staff, to meet and connect with community leaders and advocates. Those of us here at City Hall are committed to making Leadership Academy a valuable and enriching experience. I hope to see you there.
Most of us know what an emergency preparedness kit is. What if we told you there was one important piece missing from our kit that you may not have considered before? Do you have your evacuation zone written down and easily accessible?
Wait, what is an evacuation zone?
An evacuation zone identifies an area on a map with a specific number. In the event of an emergency like a wildfire or landslide, our public safety agencies will issue notices for a zone. This will let you know what action to take. Follow along with me. Let's visit the website pvpready.gov. Click on the Find Your Zone tab and enter your address in the search bar. There, you'll find a real-time status update. Most of the time, it will read normal and all clear. However, if an emergency does occur and there is a need to evacuate, you'll want to know your zone ahead of time when time is critical. We live in a very high fire hazard severity zone, and knowing your zone is critical to staying safe during an emergency. So I'm asking you.
I'm asking you.
I'm asking you. Please start preparing now.
And know your zone. Write it down and keep in places like on your refrigerator or near an exit door, even on your phone. Stay informed before, during, and after an evacuation. Know who is impacted and what action should be taken. Please visit our website, pvpready.gov, and find your zone and additional resources.
Here on the hill, speeding is on the rise.
And speeding kills.
Do you know how speeding starts?
When you're running late and in a hurry.
When you get into an argument and then get in the car.
When you have had too much to drink.
When you're joyriding.
All of these are how speed starts.
So next time, make a better choice.
Leave early so you can enjoy the ride.
Don't get in a car when you're angry. Take a walk instead.
And never get behind the wheel when you're intoxicated. Call a friend or a rideshare.
To call this meeting to order on August 26, 2025, the regular meeting of the Rancho Palos Verdes Planning Commission. Can I get a pledge of allegiance? Commissioner O'Connor, please. Thank you. Can I get a roll call, please?
Yes, Commissioner Kristen.
Here.
Commissioner Chura.
Here.
Commissioner George.
Here.
Commissioner O'Connor.
Here.
Commissioner Santa Rosa.
Here.
Vice Chair Brock. Absent. And Chair Noman.
Here. Next, any objections to approving the agenda? Is that just me? No, do we have to vote or not? No. All right.
Need to vote.
Okay, great. Next, communication, any city council items?
The City Council did adopt the landslide regulations. With that, there are references in certain points in the zoning code that just reference the prior title for that chapter, and so now that will need to be revised. Those are going to be coming back to you, or coming to you for your recommendation at the second meeting in September.
Great, thank you. Any additional staff comments or?
No, you have the memo on the withdrawal.
Got it, okay. And then on the commission, I just wanted to note that I know several commissioners attended the State of the City earlier this month in between our last review, which was well attended and helpful. Is there any additional commission comments on that? No. All right. Is there any comments from the audience on non-agenda items?
We have no one signed up to speak for non-agenda items.
Okay, thank you. Next, consent calendar. Any motions to approve the consent calendar?
I'll move to approve.
Great.
I'll second.
Any opposed? All right.
Did it need to do roll for that? Okay.
Okay. Next, on to continued public hearings. I just wanted to note that the applicant for the conditional wireless facilities permit, CELS 2025-0003 at 29,000 Southwestern Avenue, withdrew its application after the Planning Commission continued its consideration of the matter for this meeting. Next, we have new public hearings, which there are none. Continued business, which there's none. And we'll move to the new business.
Yes, for this this is our workshop for to discuss the view ordinance. I'm going to turn it over to our senior planner, John Alvarez, from our view division of the Community Development Department.
Good evening, Mr. Chairman and members of the Planning Commission. Tonight, I'm presenting an overview of the city's view restoration and preservation ordinance. First, I want to introduce the team that I have, and it consists of my left-hand man. He's actually my right-hand man, but he's to my left. This is Robert Nemeth, our associate planner. And I've also want to introduce you to the city's view restoration mediator, Ms. Colleen Berg, who's sitting in the audience. And I'm not sure how long she'll be here, but she wanted to put her face to you guys so that you know who they're referring to when you speak to our applicants and foliage owners out in the community. So first slide, please. So the view ordinance was titled Proposition M in November of 1989. And the measure was passed by the voters of the city. And in essence, it was designed to give the ability of residents to protect their views from view impairments caused by foliage and structures. The proposition was ultimately codified as zoning code section 1702.040. And today, the focus will be not on the structures, but on the view impairments. So the ordinance provides two, well, actually three critical parts of the code to effectuate view restoration or view preservation. And that's through the view restoration permit process, the view preservation permit process, and through a unique part of the code that allows the city to do an assessment of foliage whenever the city receives a development permit. So to get into the view restoration permit process, it's used when we're trying to recreate or restore a view that once existed on a lot when that lot became a legal lot. So a lot of tract houses in the community were developed in the 1960s on the east side of town. You know, we're talking maybe some in the 50s. But the ordinance harks back to a period of time when we could establish that a view did exist from a lot. And that lot is now significantly impaired by foliage. And we'll get into what that means for the Planning Commission. So view restoration decisions are made by the Planning Commission. The responsibility in terms of cost is passed on to the applicant who pays a fee, an application fee, to enter the process. And the applicant, per the code, is required to pay for the initial trimming or tree removal and replacement. So the process begins when an applicant corresponds with the foliage owner, and the applicants are asked to write to the foliage owner and to show proof to the city that they've been in contact. So proof is typically in the form of a certified registered letter sent from the post office. We asked the applicant to enter also into a pre-application process that is what we consider the mediation part of the process. And the city offers a free mediation service to do that. And we're trying to encourage neighbors to get along and to enter into a voluntary process. When an applicant and a foliage owner cannot come to an agreement, then the applicant is free to file a formal application with the city, and that formal application is something that you review. A report is written, just distributed to the Planning Commission and all the parties that are involved, and your role at that time is to visit the applicant's property. You're not required to visit the foliage owner's property, but if you're asked to visit a foliage owner's property, we would encourage you to do that, because a lot of times those foliage owners are raising issues of maybe privacy, and that would mean visiting their property to see what the privacy impacts could be. After your visit, the Planning Commission will hold a public hearing, and the commission is reviewing 6 findings. If the permit is granted, then the applicant, again, pays for the initial trimming or removal costs, and the foliage owner will be responsible for any subsequent maintenance of the trees. There's also a 15-day appeal period that's tied to your decision, and yes, the city council will hear that appeal, of course. So I want to get into the view restoration findings. The first finding is whether the applicant has complied with what we call the early neighbor consultation part of the process, which means, did they write a letter? Is there written correspondence that they could prove that was mailed to the foliage owners? And are they availing themselves to the mediation process? So the applicant's burden at that point is to show as proof of mailing, to show and to make themselves available for mediation. So finding number 2 is really the heart of it. It's the issue that most people get wrong or get right. So the finding is asking whether the foliage that's impairing the view is over 16 feet or over the roof line of the foliage owner's property. It's also asking whether that foliage could be considered a significant view impairment. So that finding it's very loaded. It's asking you to do a lot. But we do have guidelines to help you get to that decision. And the guidelines will point you to what view you are to be looking at. So the code has legally defined views. You know, those are, of course, the ocean, could be mountains, the city basin, for instance. There's also guidelines that will help you determine what viewing area you should be assessing the view impairment from. Viewing areas are typically a living room, could be a family room, dining room, but not a bathroom. So sometimes when you visit properties, an applicant may want to take you to some hallways or bathrooms, and they want you to do an assessment from those locations, but our guidelines are very clear of where we would establish a viewing area. Significant view impairments. So when you're looking at a view from a viewing area, you're considering, and the guidelines are helping you here, they're saying, well, there's a few things you could take into account. You could take into account the position of the foliage within the view itself. Is the foliage in the center of the view? Is it to the periphery of the view? And if it is in the periphery, it may not be a significant view impairment, especially if you have an expansive ocean view and the foliage in question is at the edge of that view. It may not be a significant view impairment, but foliage that's in the center, they typically are considered significant view impairments. Another thing that we look at is whether, when we're looking at a view, we're looking at typically, if you could visualize looking at a view from the northwest towards the northwest, and a view looking towards the northwest, you'll typically see the Santa Monica Bay, you'll see the Santa Monica Mountain Range, San Gabriel Mountain Range, and you'll see the city basin. So all those views are considered view elements. And what the guidelines are telling us here is look at those view elements. Look at the city basin just on its own, for instance. Is the foliage occupying the totality of that basin? If it is, then that could be considered a significant view impairment. The other thing to consider here is what is the foliage impairing? Is the foliage impairing an expansive ocean view? Is it impairing, let's just say, if you're on the east side of town, the Vincent Thomas Bridge? So our guidelines tell us which views are held in a higher regard of importance. The Catalina Island is held to a higher standard of impairment threshold. So impairments affecting Catalina Island will more likely be considered a significant view impairment than, say, a mere ocean view impairment. Next slide. So this photograph is actually a case that this Planning Commission heard earlier this year. And the location was, it was in the east side of town, and it was overlooking the harbor with Vincent Thomas Bridge there and the skyline of Long Beach in the distance. You also have some ocean view impairment there as well. So the Planning Commission, when they were considering the view impairments, they went to the viewing area of this particular property, which was a living room. And again, going back to that multi-component assessment, you have it here where you have some of the ocean being a view element on its own. There's also what you can't see here is the Santa Ana mountain range in the distance, a little bit hazy in this photograph, but it's there. There's also the Vincent Thomas Bridge being impaired by one of these trees. So the guidelines, you could use what the guidelines are telling you about multi-component views, about the location of that foliage within the view frame, being here in the center of it, and those prominent landmarks that some of the foliage is impairing. So the Planning Commission, of course, agreed with staff here that there is a significant view impairment at hand. So the commission, once you can make that finding and make all 6 findings, then the commission is asked to instruct trimming to restore the view. And in this case, it was restoration was going to be done through crown reduction for all these trees. And this is what you see in this photograph is the results of that restoration work. Okay, finding number 3 is a little bit more objective here. So it's asking whether the subject properties are within 1,000 feet of each other. Most of the time they will be. The commission won't have to struggle too much with this particular finding because most of the cases that you will receive, the foliage is within, say, 500 feet. And the way we determine what 1,000 feet is, we have a computer mapping system in the office, and we could measure out distance fairly easy. Just to give you an idea of what 1,000 feet is, this illustration shows, I believe, from the entrance of Hess Park towards Ralph's supermarket, that's roughly about 1,000 feet in distance as a crow flies.
2,000.
That's 2,000?
It is.
Oh, I'm sorry. It'll be just half that visually. Okay, finding number 4. So finding number 4 is asking whether the foliage that's now significantly impairing a view, did it impair the view when the lot was created? So the city has a number of ways to determine that. We have a collection of old aerial photographs of different sections of the town showing pre-grading operations of tracks. And we also have from LA County, all the geotechnical reports that the county engineer had signed off on at the time the track was graded. And we also have, sometimes, if we're lucky, we have photographs from ground-based photographs, maybe from one of the original property owners in the vicinity that could show us photographs of what the site actually looked like when the lot was created or when the house was built. And this is an example of another case the commission reviewed where we presented this old photograph taken probably from the early 50s?
Yeah, 1954.
1954 of the housing tract near Ocean Air Drive. And this photograph, demonstrates that foliage didn't exist on the foliage owner's property at that time. And here's an example of what one of our LA County engineering reports they usually describe mass grading operations where they removed all vegetation within the tract. And this is one of those photographs where we got lucky and an applicant produced a photograph when her house was being built. Finding number 5 is a privacy finding. So here we're looking at, would removal of the foliage cause an unreasonable privacy infringement on the foliage owner's property? So the guidelines place the burden on the foliage owner to demonstrate that it would cause an unreasonable privacy infringement. But when the city is analyzing privacy infringements, what we're looking at is does the foliage currently screen the property or the house? Would trimming, crown reduction, for instance, expose the yard or the interior space of the house and cause an infringement? So this is maybe one of those cases that, again, the commission reviewed where I believe maybe the foliage owner had made a claim for that his privacy would be affected. And here we have a row of trees and vegetation along the rear yard of the property. And by the way, the foliage owner's house is well below that, the red line there, the horizontal red line. Again, here we're looking at, if you're on the pool deck, could you casually observe the interior of the residence or the rear yard? And in this case, the foliage partially screened the property, but there were a lot of gaps in the foliage where one could easily have observation onto the house or the rear yard. And the applicant's property had a second floor with a balcony, and from that balcony you could peer down onto the foliage owner's property. So using these photographs, the Planning Commission determined that privacy was not being affected by the foliage if it were to be trimmed. And this is a result of the trimming work that occurred. Finding number 6, the last finding, has to do with the Maryland Parks and Recreation District. And within that area, it's asking whether the trimming or the removal of the foliage would strike a balance between the view restoration and the uniqueness of having old trees within the district boundaries. And here's a map of what district boundaries we're talking about. So again, if the planning commission can make all 6 findings, then it's determining what actions are needed to restore the views. And the guidelines give you 3 options of how to deal with it. One is to crown reduce the foliage. One is to crown raise the foliage. And we'll show you an illustration what that looks like. And to lace it out or thin out the foliage. And not all trees could be laced, because some trees have a denser network than others. A pine tree, for instance, could be laced, thinned out, just because of the nature of its branch network, where, say, a pepper tree has a more of a denser network of branches. It's harder to lace and have some kind of improved visual effect on trimming. Crown reduction is simply reducing the top part of the crown to a certain height level, and this is an example of what a pepper tree would look like. You can see how dense in the post-trimming photograph the tree is. Lacing, this is a good example, lacing a pine tree. It's thinning out the tree throughout from top to bottom. And this style of trimming often will work, especially on areas where the tree is blocking maybe the periphery of the view. Next photo.
This one also.
Oh, it does have, yes, the crown. So yeah, the photograph shows the combined effect of crown raising and lacing the tree. So crown raising, we're lifting the canopy of the tree, so the area below the tree is trimmed out, and the view could be improved on. So. There's also a tree removal option, but the code and the guidelines are basically instructing you to consider, when you're thinking about, if you're thinking about tree removal, consider the effects of the health of the tree, surviving crown reduction, for instance. And when you receive your reports, you're going to receive a report with one of our consulting arborists' recommendations and his assessment of the effects of trimming. So when you're reviewing the option to remove it, you're considering the arborist's take on whether the tree could handle view restoration trimming, whether it's crown raising or crown reduction or even lacing. Or you may consider that the aesthetic value of the tree will be ruined if it's trimmed to restore a view. If the foliage owner consents to the removal, then you may order tree removal at that point. But you're not obligated to replace the tree. The guidelines do give the City Planning Commission the ability to decide whether replacement is warranted. And it does ask you to look into another set of findings. So the findings to replace foliage with new foliage is whether there's going to be a significant impact on health and safety, shade, energy efficiency, those types of topics. And what sometimes you may hear initially in a view restoration case is, well, you can't trim my tree because the tree is offering shade and my electric bill will double. We sometimes hear that. You can trim a tree, but when we're looking at shade impacts, we're only looking at it through the lens of whether the tree itself could be removed and replaced. And if it's replaced, idea at least in the, say, the shade argument, is that you're going to replace the tree with a new tree that is conducive to a wide canopy for shade, for instance. And our arborists sometimes could help us determine what would be an appropriate type of tree for different functions. So when you approve a view restoration permit, you're approving it with a set of conditions of approval that will, the conditions will speak to the trimming period, when it's best to trim a tree, because like some trees are better trimmed, say during the winter time than the summer period. We'll also establish a maintenance program for the tree. Typically that's trimmed every year on the anniversary of the initial trimming. And the conditions will also speak to what happens to how an applicant is to fund the trimming. And the way we simply do that is just create a trust account in the city's finance department, and the applicant will provide some bids to the city that we will review against the conditions of approval and what the city planning commission is requiring. And if the work estimate is aligned with what the city commission is asking for, then we'll instruct the applicant to fund the trust account, and we'll ask the applicant to, or we'll ask the foliage owner to trim the foliage within a 90-day period. View preservation is somewhat different. It's used when there's an unobstructed view that existed on the date of the ordinance passing, November 17, 1989, or sometime afterwards. And there's documentation of that view. And the other criteria there is whether the foliage today is significantly impairing that view. So the decision maker in view preservation permits is the director, the community development director. And the cost responsibility is all passed on to the foliage owner for those decisions. So the process begins, again, with the applicant reaching out diplomatically to the foliage owner and trying to earn their cooperation. When that doesn't work, an applicant will submit their photographs, their documentation, to city staff. We'll look at it for a date. We'll look at it for whether it was taken from a viewing area or not. There's a number of preliminary steps we take on our end to vet the photograph and the situation. If it's a valid photograph and there is a significant view impairment, staff will notify the foliage owner that there's a pending action by the director, and we'll ask the foliage owner to voluntarily trim the foliage within a 30-day period. If no trimming occurs within that 30-day period, then the director will issue a decision, and the decision will ask the foliage owner to trim within a 90-day period. And there's a 15-day appeal period that we offer to the foliage owner or the applicant, depending on the decision. But the planning commission would hear that appeal. And I believe the last appeal you heard was last year? 2 years ago?
I think it was 2022.
2022. So when the director and under appeal, when we're looking at the review, the findings, we're looking at basically the same findings as the view restoration permit, but the critical finding, the difference here is the finding that the foliage that's impairing the view did not exist as view impairing foliage in 1989, November 1989, or sometime after that date. So that's why, so this finding looks at that photograph. That photograph is key, that documentation photograph is key to everything. It's what drives the entire permit. This is an example of a case where a resident submitted documentation to the city. We verified the date of the photo. It had a date stamp, I think, in the back. And it was taken from a viewing area. So the next step was looking at the significant view impairment the trees were causing. So we stood in the same spot as the documentation photograph, a viewing area, and we determined that foliage in this situation was causing a significant view impairment, and we asked the foliage owner to trim within a 30-day period, and I believe he or she complied with that voluntary trimming request. This is the result. So the ordinance provides the ability for staff to assess foliage when the city receives a development permit. And the purpose of that is for the city to be proactive in protecting views. Not all permits require it. If you're getting a plumbing permit, building, window replacement, some of these smaller, more novel type of permits with the city, we're not looking at view assessments. We're not looking at foliage. It's only when we receive an application where a resident is adding livable space to the property or building a new house. Trimming is required when the foliage is exceeding 16 feet and significantly impairing the view from a viewing area. So the criteria or the methodology for staff to determine whether trimming is needed is the same as it is for view restoration permits and view preservation permits. These decisions are appealable. And again, we're looking at foliage heights, we're looking at views, we're looking at viewing areas, and what we believe is a significant view impairment. So in summary, view ordinance, it's protecting views from foliage impairments. We use the restoration, preservation, and foliage analysis as the tools to make those view improvements. That concludes my report. Thank you.
Thank you. Any questions?
I have just a comment.
Yeah.
Well, I think that was very well done. One of the things I found very interesting is this is the first time I've ever actually seen photographs of after the trimming has taken place. I mean, I've probably reviewed 24 of these and never once have seen the results of what happened after the trimming. I thought that was really a great addition to your presentation. Thank you for that.
I do have one kind of question, or maybe two, that came up maybe on a previous case a couple years ago and related to the slope of a property. I know the 16 feet kind of seems like it aligns with our zoning code with the heights and related to the allowable building height of houses. But we have a lot of sloped properties in our city, and so just based upon where the house is located, it can eliminate the opportunity to have trees that are kind of upslope, I guess, of the house. Has that ever been kind of considered over the year? Obviously, you know this ordinance a lot better than I do, but Has there been any discussion about that or issues related to it, or?
Well, one thing I could say about properties with slopes, especially steep slopes, is we're not looking so much at 16 feet at that point to determine whether, the trees are eligible for review under the ordinance. What we're looking at is that whether the foliage is above the roof line of the house, and typically they would be. But sloped properties, the remedy is not as drastic as one would probably believe, because typically if you have mature trees on top of a slope and they're impairing a view, the trees being maybe mature trees are conducive to crown raising, where you could trim the understory of the tree and the resident that's affected by the trees could see underneath the trees, and the tree would lead a healthy life at that point.
Thank you. That helps. And then I had one more question. I know on maybe some comments kind of over the years, some cases in which people had recently purchased a house and then came in and cleared the trees kind of beyond their view. Has there been any history about how it seems like the view is linked with the property and not necessarily the owner? Has there been any kind of discussion points about when that, I guess, when to restore the view kind of from, or who the view is almost an entitlement to the property? Does that seem correct?
When properties are being transferred and they've been affected by the view ordinance in certain ways, then yes, the responsibility to maintain the foliage will be on a foliage owner if there's been past decisions against the foliage. For the applicant, certainly they receive the benefit of having the previous owner perhaps go through this process and get protection of their view. But maybe the difficult part for people is, they're new owners and they discover 20 years ago their property went through a view restoration permit process, and now they are responsible for maintaining foliage on the property.
John, and that also applies to the conditions of approval through a foliage analysis, right? Where the new property owner would be required for trimming of condition.
Thank you. Any other questions, comments?
May I ask a couple I actually had a couple of questions. This is my first time having the same presentation. Have there been incidents where the foliage owner doesn't trim within the 90 days, and what happens in those circumstances?
Yeah, so the city's code basically instructs the city city staff to forward non-compliant issues to the city attorney's office. And the city attorney's office will try to gain compliance from the foliage owner. Sometimes it's easy, sometimes it's difficult. Those difficult cases may require the city attorney's office to seek out an abatement, a court-ordered abatement. And the city will hire a tree service to enter the property under that warrant and perform the work and bill the foliage owner. And if we have to, we will do an assessment on the property if they don't pay.
I had one more question. For the view restoration, where it's something from the time that the ordinance went into place and after, where they need to prove that there was that there was a time through photographic evidence of having had that view. What are we expecting in those photos? Do they have to have it date stamped, or how does that work? And what is the requirement?
Yeah, so, in our modern, cameras, we have the ability to look at the metadata or date stamps, but back in the days of Polaroid taking or something like that, there was no date that was stamped on there, but there are other ways. Well, and what happened after the ordinance had passed, the city did ask its residents to, when you take a photograph, take a photograph with that day's paper, the Daily Breeze paper, for instance, the front cover, and this would establish the date in the foreground of the photo. So we have a number of photographs archived at City Hall that have that. But in other situations, what we've seen is maybe somebody claims a photograph was taken, let's say 1990, but there's no date stamp. There's nothing in the foreground that may indicate a date. What we've done is some detective work in those type of situations where maybe there's some building, house being built in the distance, or the neighbor was doing a re-roof. And we could look back at those dates, building record dates, and establish a time period when that happened.
What's prior to becoming planning commissioner last year, I think there was a view ordinance that had come up, I think a month or so before. When you have multiple parcels or multiple foliage owners have an issue, and then you've got multiple people who are getting their view blocked, how does that get addressed?
Controlled chaos.
Of course, that would be about right.
Well, our mediator makes things happen. It's through the magic of mediation that, yes, we had situations where there could be 20 people on one side, 20 people on the other side.
So it does occur that way?
Yeah, it does occur.
Right.
But through the mediation process, we filter out those situations that can be mediated versus those that, well, you will see. And the last case on Enrose was one of those. And I think that started with maybe 10 applicants and 20 tree owners. And Colleen had settled a lot of those issues. So by the time the issue came to you, I think there was 5 parties at that time, somewhere around 5, 6 parties, I think maybe.
One more question. So if I believe the city trees are not part of this ordinance, is that correct?
They're not. There's a city policy that the Public Works Department uses, but Robert and I are involved to the extent that we're the ones that are going out to the properties and assessing the impacts the city trees are causing.
Okay. So, for example, when trees are in the, say, a residential public right-of-way, how is that considered a city tree, or is that considered the residence tree?
It's a city tree.
It's a city tree. And so would staff determine that the city needs to trim that tree if needed, or?
Yeah, the way it works is, again, the methodology is still the same. We're looking at what the viewing area is, what the view is, whether the trees are causing a significant view impairment. And if they are, city staff will forward a recommendation to the Public Works of how to remedy it. And if the Public Works agrees that trees should be trimmed, then they'll send a tree service to trim it. And that's the process, basically.
Okay, thank you.
I did want to also point out, so we have I know that we had a couple months ago, our Assistant City Attorney, John Fox, had sent a communication about the distinction between the view restoration, view preservation, and then the foliage analysis that comes with another type of application. I just wanted to touch on that just so that we have it all in one presentation. I know that you had received it via email, but I wanted to just ask John if you would talk to that.
Chair and members of the commission, yes, we did briefly talk about this before. As you note, and as stated in the presentation, the foliage analysis is set forth in a different subsection of the view preservation ordinance, and that's I guess you'd say subsection B, while the view preservation and restoration procedures are in subsection C. And the point I was making is in subsection B, and it's B3 and B4, those situations come up when someone's applying for some sort of permit to add, build livable space or whatever. But subsection B does not have formal findings that have to be made. It's more of an informal determination made by staff as to what foliage may be causing a view impairment and removing it. So it's not as formal a process as the process set forth in subsection C, which can become, as you know, unfortunately adversarial. And so the result of that is the analysis that you receive for view preservation applications or view restoration applications is generally more detailed because you are dealing with an application specifically to either preserve a view or restore a view. And the foliage analysis in subsection B is not as formal, and it's not subject to strict findings that have to be made. So.
Question, so that in subsection B, is it more appealable in a sense, or not appealable, but is it less binding than, say, subsection C in terms of a voter mandate, or?
No, if staff determines there is a view, a view impairment, they condition the project, as Octavio stated, to restore or remove whatever is causing the foliage impairment, and that becomes just as binding as any sort of determination under subsection C, and subsequent property owners would be subject to those conditions to maintain it. It's just not as formal. When you have to make formal findings, you have to support those findings with what is called substantial evidence. It's just a much more formal process than the foliage analysis that is done. But they both can ultimately result in binding requirements on the property owners in the future. So.
And this is one of my issues, right? Is I think your description is incredibly an understatement. In a foliage analysis, we'll get one sentence that says staff determined that there's a blockage of the view. In a view preservation appeal or a view restoration, we'll get 75 to 100 pages of criteria. So the difference between substantial and not so substantial is 75 pages minus one sentence. However, another significant difference is when the city is acting as the entity determining whether there is a blockage or not, they're not responsible for paying for the trimming as they would be in a restoration. The applicant who wants to build a house, or he's responsible for paying for tree trimming that the city has determined. And so another asymmetry to me is that a normal citizen who has a view blocked needs to pay, other than a preservation, for that to happen with an 80-page document. But the city's only required to say they think that there's a blockage and compel the homeowner to pay for it, right? So the asymmetry between payment occurs as well. And correct me on all those statements, but that's been my experience. And believe me, we've spoken. I understand what you said about the substantial difference. I just think it's an understatement, right? Because it's one sentence versus 80 pages. But thank you.
And those are fair concerns. The determination by staff, though, is also appealable not only to the Planning Commission, but to the City Council. So, so there is a remedy for the property owner who feels that staff's determination under the foliage analysis is not reasonable.
Yeah, and I certainly agree that's everyone has a chance to appeal, and I'm not sure that I've ever seen one that's been significant where the cost was significant. Certainly not in comparison to the cost of whatever remodel or building that was being done, right? So most applicants will simply assume it's the cost of doing business, right? But the criteria is nowhere near the same, in my opinion. I mean, you would have to go into the backyards of many people's houses around a new construction, but you're not going to, the staff is not going to go into everyone's backyard as they would do in a view restoration, right? They're just making an informal determination. I think is a quite apropos statement to that. And so my opinion has always been, it's to find egregious cases, and that's probably what you've done in the past. The staff has done. I don't remember anyone bringing one that I thought was not egregious, but nonetheless, we take our views very seriously in this city. and you know, it is a question that you have precipitated in me, if I might ask. The view preservation and restoration was passed by ballot initiative. Was the foliage analysis part also a ballot initiative, or was that a city council?
The foliage analysis was part of the original Proposition M.
Was it? Okay, thank you.
I'm just following up on this. When staff goes out for this foliage analysis, you're essentially looking for what's blatant and obvious. I think you finally got to that point. It's just really because you're looking at the subject house that's planning the remodel or construction, and then you're just seeing what is beyond the ridge line. I mean, what criteria are you utilizing? It would probably be the same.
Yeah, when staff goes out, they'll evaluate, looking in the neighborhood, where there might be those potential views from seeing what we've, the experience of the applications we have had for view restoration or preservation, and then reaching out to those property owners if they have, and it's typically when they have the silhouette up, so they've been notified that there's a project that's being considered, and that gives them the opportunity to reach out to the city. And we've had this where there have been property owners that have, expressed some concern, and then we'll go out and do that evaluation of their viewing areas to those exact points that John was making of, is there a view, is there a viewing area, is there a significant view obstruction? But it's really, it's going to be mainly looking at those properties that where we are pretty certain that there's that view, where we can see that from those locations, or where a neighbor has reached out during that notification period.
Okay. One more question. On this same topic, if the property that's getting remodeled has foliage that is excessive, but there are multiple properties down view that are still blocking the view, whereas it's different than the view restoration where it clears out everything in the past. Is it still actionable on the single uphill or close to the view property, even though it won't have an immediate impact on opening the view.
So typically, the most impacted neighbor is going to be the closest neighbor to where the subject property is located. But let's say that in the hypothetical situation, we identify the most impacted resident property, and we ask for a certain type of trimming to occur. After the trimming occurs, most properties beyond the immediate neighbor, there could be a view impairment, but what we're looking for are significant view impairments. So after trimming occurs, it's less likely to be a significant view impairment. If there is any impairment at all after the trees are trimmed.
I'm not sure that got to because I understand what you're asking. Yeah. I think it's, if you have somebody who's the applicant and they have some foliage and there's a neighbor that says this foliage is blocking the view, but then if you were to do, like, say, a crown reduction, and there's now another neighbor that has something beyond that blocks that. Would you require them to do that crown reduction, knowing that there might be something down the road that
different
might be...
layer, like a layering of foliage? Yeah, well, because the person that's affected by a certain number of layers, we couldn't apply the foliage analysis section of the code for all the properties. They still have that ability to go through the view restoration permit to to address all the other layers. So the way I think we would look at the subject property, development property, is under those circumstances, is that if somebody was passionate about recovering their view and there was only one section of the code that could be applied to the situation at that time, we would probably look at it from the standpoint of trimming the foliage with the understanding that the foliage owner, or excuse me, the person that's affected by the foliage impairment, it will be pursuing a view restoration permit.
Of course, his alternative is to try to encourage the other people to do a remodel.
Oh, yeah.
Any other questions? Thank you. That was really helpful. Thank you. All right. Next, we're moving on to items for future agendas.
Yes, for the September 9th pre-agenda, we don't have anything for that. So at this time, we're expecting that meeting will be canceled, just because anything that would be on there would need to have a public hearing notice already. And then for September 23rd, as I mentioned earlier, we'll be bringing those very minor code amendments that are the references to the landslide regulations that are in the zone, those small few references that are in the zoning ordinance, and we'll be bringing those before you for recommendation to council.
Can I ask Chairman, can I ask a question there? So those were not already approved by the council?
The landslide regulations themselves were, because they are located in the building code. But there are, it's 15.20 is that chapter that the landslide regulations are in. The thing is, there are some areas in the zoning code that call it what it used to be called, which was the landslide moratorium. So it's just clearing that up. So you're going to see that in the underlying strike through, that's just calling it by the new title of that chapter.
Okay.
Yeah.
Okay.
They're very, very minor changes. It's not the landslide regulations.
We have to have a meeting for that?
There has to,
Okay,
it's a revision to the zoning code, so it has to come before you, yes.
Fair enough.
Is
Okay. Thank you.
the cargo containers for habitable space?
What's that?
The 1776.780, is that the cargo containers? It's
That
for
has a
converting it
reference to it.
Habitable space
It wouldn't be habitable space.
for storage.
Is this a reference to using cargo containers to ballast your home against?
Yes.
Against the?
Yeah,
Some houses
it
are
would
built
be-
with 3 cargo containers filled with cement that can be rocked to balance your house.
Yeah.
Sorry.
And you know what, this is going to be the topic for that, so I don't want to get into like the details
Fair
of what
enough.
you're going to be discussing, because we'll discuss it at that hearing.
Thank you.
All right, thank you. I think after that, we have adjournment. Any motions to adjourn?
I'll move to adjourn.
I'll second that.
All right. Any opposed? All right. We are adjourned. Thank you.